Good morning, everyone. I'm just going to wait for a couple of seconds so that everyone can get into the room if they need to press any buttons or anything. Yeah, I can see people are joining on the attendees. I'll just give it a couple more minutes. So, hello and welcome to everyone to the first of what we at Thomas Mansfield hope will be the first of many webinars for employers. I'm Angie Crush. I'm one of the partners here at Thomas Mansfield, and today I'm joined by my colleagues Jonathan Mansfield and Meredith Hurst.
Hi.
Morning.
Hello. Morning.
Now, many of you attending this morning may already be our clients and know who Thomas Mansfield are, but for anyone who doesn't, Thomas Mansfield started off life as a specialist employment law firm many years ago. And we have a team of specialist employment lawyers here, all of us dedicated to employment law. We work very closely with businesses, very often with the HR managers, but sometimes also with the business owners where the business doesn't warrant a separate HR function. As well as the employment offering, Thomas Mansfield for a couple of years have had a separate family law branch and also a specialist private client branch as well. I'm not sure how busy that family law branch will be after the lockdown with all the family strife that everyone's in. So we're going to be concentrating on issues facing employers, and on Sunday the government announced the beginning of the end of the lockdown period. Now, employers are going to be affected very differently depending on what sector they're in and also their individual circumstances. And for many, we recognise that income streams aren't necessarily going to return straight to what they were pre-lockdown levels. So most businesses are going to have some tough decisions to make in the coming months. What we're aiming to do in this webinar, so we have got areas for discussion, but we'd also like to take the lead from you. And if you want to sort of ask any questions, then you can do that by asking in the chat box. So at the right-hand side of your screen, there's a box that says chat, and you can type your questions in there. And during the course of the webinar, I will try to ask the others those questions, and we'll get the answers for you. And I've just noticed in the chat box, someone has said there's no sound.
I've had that as well, actually, yeah.
But is anyone else having problems with the sound, or is it perhaps just the settings on that person's computer? Oh, okay, they've come back and said, yeah, it works fine, so don't worry. Okay, perfect, you can hear us. So yeah, please do put any questions in the chat and we'll try to get them answered. We're going to be looking at two things. One is the sort of current lockdown period and the issues mainly arising in that. And then Meredith is going to be focusing more on the period coming out of lockdown, what employers, have to do going forward, and the issues that are likely to arise going forward. So a couple of people have emailed me questions in advance of the webinar. So to kick off, I thought I'd start with one of those questions. In fact, it's sort of a bit of a four-part question that someone has. And it's probably a topic that a lot of you have had to think about, or maybe are thinking about. So it's annual leave, Jonathan. So as probably most of us know, the Working Time Coronavirus Amendment Regulations has amended the Working Time regs to enable workers to carry over some annual leave. So, but the questions that we've got specifically are these regulations intended to apply to all workers across the board, regardless of whether they're key workers? What is the panel's interpretation of the words "where it's not reasonably practicable" to take their holiday? And also, what can companies do to insist that workers take their annual leave this year and don't carry it over to future years? And then there's a final question about holiday and furlough, which maybe we'll take in a moment.
Okay, well, first of all, in relation to the new rules, they're not limited in themselves to a particular sector, but of course the criterion of it being reasonably practicable, not being reasonably practicable to take the leave during the year for a reason related to the coronavirus, does mean that it will tend to be those who are in key worker areas. There clearly have to be certain limitations on this, and the government's produced some guidelines recently on it. Has there been a significant increase in demand in that particular area because of the coronavirus? Has that workforce been affected by the coronavirus? Has it been disrupted by people self-isolating and so on? Also, is it practical to get temporary cover in, is another consideration. But you have to also look at the case of a particular individual, because if that particular individual has health problems and needs the rest and recuperation of annual leave, you may have to be careful about making use of the provision in that case. Another criterion is the effect of the virus on the society as a whole. So is it in a workforce where they are needed to help us get through this crisis? And employers should really be trying to allow employees to have as much as possible as their leave as they can. I should just mention a couple of technical points with regards to the provisions as well. One, that it only applies to the 4 weeks which derives from the Working Time Directive, and it doesn't include the whole 5.6 statutory minimum leave. So it's only 4 weeks. You could possibly have an arrangement in place through a relevant agreement for the other 1.6 weeks, but this provision only deals with 4 weeks. And of course, there's another side to this as well, which is that for a lot of employers, it's going to be really important for people to take their leave, because one of the questions we've been getting a lot is about people sort of accumulating their leave because they haven't been able to take holiday because of the travel restrictions. So that raises the question as to whether you can make employees take leave. And as a matter of fact, you can, unless there's some contractual provision preventing it. There is a working time under Working Time Regulations, Regulation 11, there is a provision which allows employers to designate time to take leave, provided they give at least twice notice of twice the length of the leave to be taken.
I've certainly had many of my employer clients use that provision from the outset, so we can't have people building up leave and wanting to then take it all when we get busy again towards the end of the year. And they've been using those provisions to say, look, we don't normally do this, but now we want you to take the leave. We're giving you notice. You've got to take a week's leave in 2 weeks' time, and they're starting to make people use those chunks of leave. So yeah, I've definitely seen that with mine. And would you say it's fair to say, to sort of answer the specific questions, although it does apply to workers across the board, most workers are going to be able to take their leave, and they're not going to be able to insist on using these regulations, and therefore employers will be able to just ask employees to take holiday in the usual way and indeed insist on it.
Yeah, I think that's absolutely the case. And indeed, one of the things that's come up is about taking leave during furloughing. It's actually perfectly possible. The government guidance states that annual leave can be taken during furlough, although you do have to be careful that if it is a period of annual leave, rather than furlough leave, there has to be a top up to the 100% of pay during that period of time.
One just to make this webinar a little bit more interactive, if possible, and I hope the technology works. Again, on the right-hand side, there's a polls button, and just as a matter of interest, I've put a poll on there to say, have you required employees to use up annual leave? So perhaps if you could just go to that polls button and all of you just clicked, it'd be interesting to see what sort of proportion of employers have already used the ability or think they might plan on using the ability going forward. And I can see the poll results are going all over the place at the moment. I'll wait a couple more seconds because I can see that people are still voting on that at the moment. And then I'll end it and you should be able to see the results. So at the moment, we've got 42% of people have required employees to take annual leave, 31% haven't, and 33% haven't yet, but will do. If I end that now, hopefully you'll be able to see the results of that. So it's a fairly broad mix of yes, we have, no, we haven't, no, we haven't, but we will do. So, but hopefully, you know, that guidance from Jonathan enables you to at least know that you certainly have the ability to do that if you want to. One of the other sort of questions that's come to light, everyone is talking about it, is furlough leave, and I think most people know now, you know, what's covered in furlough leave and that sort of thing. So I thought I'd ask you more. What are the danger areas for employers using the furlough leave? Okay. Where do you think employers might run into trouble?
Yes, well, I guess the first and biggest danger is with employers kind of playing with the scheme. It should be remembered that HMRC reserves the right to audit any applications, and in cases where dishonest or inaccurate information has been given, they will seek repayment. And although the guidance originally said that it was for businesses which were severely affected by coronavirus, the actual criteria for using the scheme are very broad, and so it's been nearly 25% of the workforce is in fact furloughed. And it doesn't mean there's not going to be some scrutiny for abuse of the system. A key point for employers is that employees mustn't do any work while they're on furlough, which is defined in the government guidance as not performing any services or generating revenue. So there are some things that they can do, like training to improve themselves, which could be funded by the employer. That's absolutely fine. But the temptation to spill over into doing bits of work should really be avoided and prevented. A difficult area is with statutory directors. They have to fulfil their duty, their governance duties as statutory directors. But again, allowing that to move over into doing services more generally to the company should really be resisted. Of course, it now looks as if after it's been extended to July, of course, but after July, the scheme will continue in some form, and it may well be that it's going to be adapted so that there can be partial furloughing, which I think is one of the things that commentators, critics of the scheme have said, that it's a pity that you can't at least have some sort of combination of maybe furloughing for a couple of days. The second area, I guess, of real concern is how you decide who is going to be furloughed. And this is particularly the case where employers, and the majority, I believe, are not doing this, don't make up the pay to 100%. Some employees may feel aggrieved by being chosen. You need to think about avoiding potential discrimination claims. For example, making the assumption that a woman, because she has young children, will want to be furloughed. It could give rise to a potential discrimination claim. Look at your business needs and the skills needs and make the decision on that basis.
Guys, we've had a question actually come in. I don't know if you've seen this. If you've made a temporary reduction to the salary as a result of COVID-19 and have now furloughed staff, and they are now requesting holiday should the top-up holiday pay be at the full pay rate or the reduced rate? And I think that possibly depends on whether you've revised the contract, and therefore the rate of pay is permanently reduced until the contract is revised back again to the previous position.
There are some sort of regulations that give specific calculations to how to calculate holiday pay, depending on whether your worker has sort of regular hours, regular pay or irregular pay. And in some cases, so from the 6th of April, actually, there were changes, and you have to look back over the past 52 weeks. I think the general consensus seems to be that it should be normal pay. So whatever normal pay was, because you'll be looking back at normal pay, it will be that, rather than the temporary reduced pay. Certainly that is the safest approach to take. You could look at individual cases and see whether you can make yourself come out of those exceptions, but I think in the main it will be normal pay for people on holiday.
Thanks, Angie.
Sorry, going back to the furlough, hopefully that's answered your question. There's another question come in about furlough and what's the of staff who are not going to be made redundant, and furlough is not offered as a mitigation, even though they could stay on until the end of July. And I think it's probably a question a lot of people have got. If an employee is being told now, look, you're at risk of redundancy, and we're not going to use the furlough scheme because we can see that we're going to need redundancies. The employees very often are saying, can you just keep me on until the end of July? Because, you can use the scheme. I don't know what your thoughts are. Mine are that there's no obligation to keep them on. If you can see there's a redundancy situation that's going to be there, you can go ahead and make that. And there's various reasons why, as an employer, you may want to do that. Certainly, I've got clients who are making redundancies because they can just see that it's not going to be possible to employ everyone.
I mean, I think it will be used as an argument in the context of unfair dismissal, possibly, if an employer hadn't at least considered it and hadn't documented the reasons why it wasn't appropriate. So the point about mitigation, I think, yes, as an employer, you should at least consider it and discount it, and be clear to explain why you've selected certain people. And that plays into another question we've had: can someone be made redundant while on furlough? Actually, that's a slightly different question. But in relation to the failure to furlough, I think failure to furlough per se won't be a problem, but I think failure to consider it and explain your reasons why you haven't will be problematic.
And I think in answer to the question, can someone be made redundant while on furlough? I think it's clear, yes, absolutely they can. Being on furlough doesn't give any additional protections from the usual redundancy processes, and absolutely it would seem you can consult with them while they're on furlough, and you can indeed make them redundant while they're on furlough, and even you could have a part of their notice period while they were on furlough, although again some questions would come in about topping pay up if that happened. So, any more dangers with the furlough scheme that you can see, Jonathan, in particular, maybe around the sort of normal employment law continuing to apply? Because I know all of us in the firm have seen some interesting scenarios with employers that think that this perhaps isn't the case.
Well, yes. I mean, in effect, what is the furlough scheme? It's a subsidy. It's a scheme that is a government subsidy, and it doesn't really displace normal employment law. In one way, it seems completely obvious, but some of the inquiries that we have had indicate that this isn't the case. When we had an inquiry from an employer who had furloughed a group of people, they were employees, but the criteria require that they were on payroll at the 28th of February, or that was revised later to the 19th of March. And these employees weren't on payroll at all. And the question we were then asked is whether we had to pay them, the employer had to pay them at all. So, you know, it has obviously caused confusion in some areas. One area which is very important, of course, is agreeing to furlough. The guidance itself requires, as does the Treasury direction, that the employees agree to the furloughing. And there was some controversy as to whether you needed to have the actual written agreement signed by the employees, but the guidance at the moment suggests that you don't have to have that back, although obviously it would be very sensible and good practice. But of course, it is also a change of their employment contract itself, and so you need to be thinking about what the implications of that if you're reducing, you know, pay, especially, and it does need to be agreed by the employees. In many cases, it's going to be accepted by the employees because the alternative will be redundancy. But of course, remember those points that we made a little bit earlier about selection. Another area which comes up in this is, as well as individual consultation with employees before you furlough them, if the alternative to furlough means that employees would be dismissed and there are 20 or more of them, then collective consultation becomes an issue. That's consultation with representatives. Of course, there's real practical difficulties with this in the time constraints that we have at the present moment. And of course, and we've had, you know, problems, well, very strange problems actually. In one case, we were advising an employer who approached the union in order to consult, and that union, it was the union itself which refused to consult because they said that it can't be done in these particular circumstances. Now, the response to that is not going to be to not carry through with your statutory obligations, but to do what you can that's reasonably practical in the circumstances. Now, I mean, there is a, if you can't do it, there is a special circumstances defence which might apply in this particular area, but you still have to do what is reasonably practicable and do consult as best you possibly can in this circumstance, and also, you know, get advice on ways to minimise the risk, because there's still a lot to play for. The level of compensation could be very high for a large group of people, but you could minimise that if there was a claim further down the line by making your best efforts. Another couple of things that have come up. One is that whether people could be rehired if they'd left and then come back onto the furlough scheme. And surprisingly enough, the scheme allowed for that. And then the other question is whether people who were off sick and perhaps down to statutory sick pay could be redesignated as being on furlough leave so that it get subsidised effectively by the government. And again, that is possible provided they don't get both benefits at the same time.
Just to sort of see, we're hearing on the news all the time about the take up in the furlough scheme. If I've just put another poll on just to see, you know, out of the viewers, how many of you have made use of the furlough scheme? So if I've put that poll up, if you can just answer, if just be interesting to see, you know, if everyone is using it in some shape or form or not. At the moment, the results are showing 50-50. Actually, it's going up more now towards yes. I'll just give it a couple more seconds. I mean, certainly, I think out of all my employer clients, I can't think of any who haven't used it at all with anyone. So pretty much 100% of my clients have used it for at least some members of staff. It looks like most people have voted now. So the results of that are that 72% have used it, 28% haven't used it. I'm hoping when I stop the poll, you can see the result. I don't know if that's, but over 2/3 of you have used the furlough scheme in some shape or form, so that's quite interesting. Going back to, there's a couple of questions come in here. One of them is, it says that the government have said that if a temporary reduction in salary has been agreed, the furlough scheme for that individual cannot be used. Has this now changed because this particular person has furloughed some, agreed a temporary reduction in salary for others, and is then thinking about rotating the furlough? Now, I have to say I have not seen anything in the actual government guidelines, and I've taken a view, I'm not reading other people's commentary on that, just read what the government publishes. I've not seen anything, although versions come out on a basis, it seems, it says that if there's a reduction in salary, you can't use furlough, because having a reduction in salary is just a matter of what you agree contractually with your employee. But have either of you seen that? What are your thoughts on that question?
I think the way round that particular issue, I don't think the guidance has changed as far as I know, but I guess there would be a way around, because I think part of the problem was because of when the scheme came in, people had already started to take these various measures. You could you could reinstate the original level of salary. That would be one way of doing it, and then put the person onto furlough. That, I guess, it would be a sort of practical way around the problem. But yes, it is one of the quirks of the scheme, given how sort of broad and generous it is in so many other ways.
And from the 1st of August, the option of part-time furlough seems to be available. Of course, that's based on press release last
we're
evening.
still waiting for the detail on that, aren't we?
Yeah.
And then another question is whether an employer can require a full-time employee to accept a reasonable part-time position at the end of the furlough period.
I mean, I replied privately to that, but I would say potentially yes, subject to consultation and agreement. But rarely will a contract have an express provision with a power like that. So a general variation provision wouldn't necessarily get you home on that, but you'd agree it is an action short of dismissal if redundancy was in the offing.
I was going to say, what you would generally do, or certainly I would probably generally do, is to say, well, commence a redundancy consultation, offer the role as part of that, and someone's going to be faced with redundancy, or they accept the part-time role. That may be a way around it. I'll come back to a couple of other questions in a moment, but just to sort of move through the other areas that I know, and there's some questions coming up on going back to work as well. One issue that a lot of employers are going to have is we've had this extended period of everyone working from home, which many employers have resisted too much home working for quite some time. And so what do you think are the sort of implications likely to come up in the future, Jonathan, around flexible working, home working? What problems is this going to throw up for employers going forward?
Okay, well, I think the flexible working requests are probably going to become more frequent. I mean, without going into the mechanics of making a flexible working request, I think the issue for employers is going to be thinking very carefully about the criteria they use for refusing requests, because remember, you can get claims arising out of these. The claims most frequent are indirect sex discrimination claims, and also claims arising out of a disability where it's a reasonable adjustment issue. I mean, I have been dealing with a case where there were, recently, where there's a very flimsy refusal on, in the case of a disabled employee, very flimsy grounds for refusal of home working with someone who's got agoraphobic symptoms. And you know, I think that sort of thing is, it's not going to wash in, to some extent, it doesn't wash in tribunals already. You've got to have a very good justification, objective justification, defence if you're refusing flexible working. But I think there's going to be the argument always out there, oh, well, it was perfectly okay during the lockdown. Why are you saying no now? And I think that's one of the things you're going to be finding more and more.
And I'll be covering people who are perhaps resistant to coming back, and we've had a question in about that, so I'll cover that shortly.
Yeah. So maybe thanks, Jonathan, for everything there. I think perhaps just to cover one question, which sort of then may tie up the sort of furlough side of things, about whether a recruitment agency who won't furlough their staff, even though they meet the eligibility criteria, but they're not actually offering candidates work, even though they say there's work available, so they won't furlough, and what can be done. And if it can be resolved and the agency can be persuaded to furlough, can the payments be backdated to 1st of March? I think furlough is not an entitlement, and obviously it will depend on the mechanics of their particular contracts. If they're on 0 hours contracts or something, if they have no entitlement to work, then they may be in a tricky position in forcing that agency to furlough them. But if they are persuaded to furlough, I guess it's difficult because there needs to be an agreement in place that you won't do any work. And so whether or not you can do that retrospectively, what they may have to do is to look back and see, well, you know, if it was clear that they weren't doing any work, it may be possible to use the furlough provisions. I mean, in terms of backdating, I think it's a matter of practicality as to when they happen to make the claim under the portal, as much as anything else. So I think they'd still be in time, but they'd have to look at whether they satisfied all the tests, i.e. they definitely, you know, they had agreed not to do any work and all of that, those tests that are in place, to see whether they would sort of legitimately be able to say, yes, we met all the tests, and therefore we can backdate it to whenever they stopped being provided with work. That's hopefully sort of helps on that score. So Meredith, looking forward to, as you know, as we're coming out of lockdown, and I think employers are, you know, starting to think about how to get their workforce back. And as you said, we've already had one question. The reluctant employee doesn't want to come back to work, doesn't want to come back into the office, that sort of thing. What maybe talk generally about the sort of the return to the workplace, and then sort of answer this question specifically.
Yeah, well, we saw His Lordship's announcement on or briefing on the 10th, which the TUC described as a recipe for chaos. But that suggested pretty bluntly that people now have to get back to work and actively were encouraged to return to work, particularly in construction and manufacturing. But the devil is always in the detail with these things. Beware the press briefings, because they are ideas rather than guidance or formal recommendation. The government then followed up with its formal guidance, which is it's a 50-page document. For obvious reasons, I won't be covering it all here. That makes extensive sector-specific recommendations. So for each sector, there are different recommendations about how you go about creating a safe place of work. And that is the emphasis of the guidance, making workplaces safe. The guidance is called Working Safely During Coronavirus COVID-19. But the common thread running through the guidance is the requirement for a risk assessment. It's slightly unclear as to whether a risk assessment is compulsory, but for reasons that I'll outline, we think it's sensible anyway for employers to carry out risk assessments, not least to militate against allegations of health and safety breaches by employees, because if you've got a risk assessment, you can demonstrate that employee's belief in an unsafe place of work is not reasonable, perhaps. But the TUC had wanted employers to have a risk assessment before the workplace opens, but I don't think the government have gone quite that far. but they do say that a risk assessment must, and I'll read from the guidance here, the risk assessment must make sure that it assesses the risks of COVID-19 using the government's guidance. So it's very important that you review that. A risk assessment isn't about creating huge amounts of paperwork, but rather about identifying sensible controls. If you have fewer than 5 employees, then the risk assessment doesn't have to be in writing. But it's important to bear in mind, actually, that the guidance shouldn't be seen as a charter to compel all employees back to work. So it's not a sort of one-size-fits-all approach. And in fact, whilst it identifies those people who should go back to work, such as those for business continuity purposes, directors and so on, who are actually there, who are there for important business continuity reasons, it makes clear that staff should continue to work from home if at all possible. So in that sense, certainly in respect of office-based environments, nothing's really changed. So I think that's something to bear in mind. Yeah.
So if you have the reluctant employee that actually can continue working from home, they've probably got a case in line with the guidance to say, well, there's no reason that I need to come into the office.
Possibly, yes. I mean, I would say, yeah.
Different, I guess, if you work in something where you actually can't work from home, maybe you're even furloughed, and the government are saying, come, really, we need to get people back to work if they can't work from home. I mean,
yes. I mean, the reluctant employee.
What do those people?
Well, the reluctant employee, I'd say that the employee who raises concerns, and this is a tricky area in some respects. If the employee can work from home, then of course that's your solution there. But employers should look at the specific reasons. I mean, this is an obvious point, but you'd look at the specific reason why that employee has resisted coming back to the workplace. You'll have those who are socially isolating for medical reasons. Well, of course, they would not be expected to return. You'd have also those who fit into a category who are perhaps living with somebody who's shielding, vulnerable, or themselves socially isolating. The guidance is pretty clear on this. It doesn't prohibit the individual returning to work if they're living with somebody who's socially isolating, provided they are adhering to social distancing measures themselves at home. There are other categories, such as those with disabilities. Not all disabilities per se will preclude someone from returning to work, but it may do if their disability means that they are more prone to contracting the virus. So if they have a respiratory condition or something like that, then it would be dangerous, I think, to insist on that person returning to work, because blanket policies will rarely cater for everybody, and that person could have a discrimination claim.
So really the key is to look at the particular reasons that individual is giving.
Yes.
Look at the guidance, look at the criteria, see whether they fall into it.
Yes.
But if it's just someone saying, I don't feel going out, then the employer can be fairly sort of forthright and say, no, you need to come to work. You've got work to do, and you can't do it from home, and you need to come to work. And sanctions may follow if they don't.
I mean, in the sorry.
I was just going to say, practically, what sort of measures do you think that employers can implement to make things safer? And also this question about face coverings, what's the position on that? Okay,
before I get onto that, I'll just quickly cover the health and safety point, because I think that this is something that employers maybe aren't aware of. But if somebody raises health and safety concerns and they're subjected to a detriment, or they're dismissed, and that can be automatically unfair. The question of what is a reasonable concern, and this goes to your point, Angie, about somebody who, for no apparent reason, just doesn't want to come back. I mean, I'm sure there's lots of people who've still not got through all of their beer delivery yet, and just more than happy to stay at home. But for those individuals, if somebody reasonably raises a concern about their working conditions or other circumstances that they believe reasonably are likely to cause harm or have the potential to cause harm, then employers should be careful about that. It's a potentially litigious area. The law is there to try to balance between the overly cavalier employer and the overly sensitive employee. So it's not an easy one to deal with. But something actually Angie mentioned yesterday was that it wouldn't be reasonable for an employee to simply say, I'm not coming back, unless they'd at least tested the water and gone back to work to see what the working environment is like. And again, going back to the risk assessment, if you've got a risk assessment in place, then that is certainly going to assist you as an employer to say, look, it's not reasonable for you to refuse to come back. There's a second category, which is the person who takes evasive action. And I was thinking about this morning as my children were building some Jurassic Park Lego. This is really the Jurassic Park scenario. So the T-Rex has escaped from the enclosure, and you have to avert imminent and serious danger by running away in that case. Now, I can't see that necessarily being relevant in a COVID-19 scenario unless you're in a clinical environment and you've got a rogue patient going around spitting at people, in which case you probably would have to avert yourself or get out of the place as soon as you can. If the employer dismissed you for that, then that would be potentially automatically unfair. Then going to your point, Angie, in respect of the steps that can be taken, I'm sure a lot of the viewers today will already be thinking about this, depending on what sort of environments you have. In an office environment like ours, we're going to have to think very carefully about social distancing measures. And the real impetus in the guidance is all about social distancing. And things like reception areas, how do you deal with that? The Retail Consortium have already provided guidance on this, published on the 26th of April, which deals with things like having perspex screens at checkouts, regular announcements in the workplace about social distancing, and that's more relevant to larger workplaces. In office environments, you're looking at things like fixed teams. I know of a vets practice who are operating a fixed team system so that 3 vets are working together. You can have, so they're not going to be in contact with other people. You can have staggered shifts. So staggered shifts, staggered start and finish times, if that works. It may not work for everybody. The face coverings and the PPE is a bit of a hot topic, I think. The government is at best equivocal about this. And actually looking at the guidance, they seem to be actively discouraging. And I don't know if that's a political point, really, given that the issues in clinical settings. If you already wear PPE, say on a building site, then you should continue to do so. But workplaces should not encourage, and this is reading directly from the guidance published on the 12th, workplaces should not encourage the precautionary use of extra PPE to protect against COVID-19 outside of clinical settings, because PPE that is ordinarily used is not geared up for the COVID-19 scenario. But interestingly, if your risk assessment requires that PPE must be worn, then you also have to pay for it. So bear that in mind. Face coverings. Now, the evidence suggests that wearing a face covering does not protect you, interestingly, or this is certainly what the government guidance states, but it may protect others if you're infected but have not yet developed symptoms. But wearing of face coverings is not a legal requirement. And as I say, the emphasis is very much on social distancing. Now, that may be possible in fulfillment centres. Amazon seems to be managing fine, but it may not be as easy in a very small office where you may have to reconfigure the physical space, and you may need to have partitions, as I say, cleaning high-touch areas, high-touch surfaces, constant reminders about hand washing and that sort of thing. Staggered shifts, fixed teams, face-to-face meetings, that sort of thing have to stop.
We're sort of imagining that employers are going to perhaps bring some new policies in to specifically deal with, social distancing in the workplace and what people have to do, what the expectations of the employer are to try and cover themselves. What policy general do you think employers should be looking at and thinking, do I need a new policy on this? Do I need to revise this policy? Because I think that the whole situation has made us think, well, if this had never been envisaged, but it would have been good to have line in this policy that says this or that. So what do you think employers need to be looking at going forward?
Yeah. Okay. Well, I mean, yeah, thank you, Angie. Jonathan touched upon annual leave. I think the carryover piece will be quite an interesting area, because obviously employers don't want to have a glut of people making annual leave requests. But of course, you've now got this statutory right to carry over. So as we saw, I can't recall if we actually did a poll on this, but the point about requiring people to take leave, you may want to be reviewing your carryover policies. You may have provisions in contracts that allow you the right to carry over. So you may want to be looking at that and compelling people to take annual leave if possible. There may be, there may be a requirement to take emergency volunteer leave in some cases if people are still volunteering and assisting during the pandemic. Areas where business is going to have to consider cutbacks, we'll get onto redundancy possibly in a moment, but things like reducing pay, reducing hours of work, as someone has asked in the chat, will require sensitive management and consultation. You may want to freeze pay reviews. You'll be looking at, perhaps I had a client who wants to defer commission payments, bonus payments, incentives, that sort of thing may need to be revised or revoked. And of course, that will depend very much on the specific terms of the scheme that you operate. You may indeed want to introduce a social distancing policy as part of your risk management strategy. And if you haven't already considered home working, I'm sure a lot of people are already doing this, but you may want to look at your home working policy and make sure that it's fit for purpose, as well as flexible working policies, which Jonathan covered. And there are a whole host of things, yeah.
If employers are looking to, for example, change contracts in some way or make some amendments, what sort of key things do employers need to remember?
Okay. Well, I think the starting, yeah. Well, the starting point will be the contract. I mean, do you have an express right to vary? You need clear and unambiguous language in a contract to be able to vary specific terms, such as place of work, pay, hours of work, job functions, and so on. Rarely will a contract provide, well, I say rarely, if it's a well-drafted contract, you may well have that express power. Even if you do have an express power, though, it doesn't mean you can simply haul your employee into a room and say, we're changing your job. You still need to exercise that power in a manner which is reasonable and which does not breach the implied term of trust and confidence. So the classic case is a mobility clause in a case of ACTAR, where the chap was required to move, I think, from Leeds to Manchester or vice versa within the space of a week. So that wasn't reasonably practicable for him, and he resigned and he won his constructive dismissal claim. So you need to be sensitive and consult about these things. If you don't have an express term in the contract, then you're really looking at seeking to reach agreement with employees. It's a brave employee, I think, in the current climate that will say, no, I'm not going to take a pay cut or a reduction in hours and resign and throw themselves at the mercy of the job market.
I think practically at the moment as well, with making these changes, it may be that employers can propose them on a temporary basis with a review period. Do you think that's more likely to be accepted than a sort of permanent change to the contract?
Absolutely.
And through this next period.
I mean, it's a very good point, actually. And I was discussing it at home only yesterday with my wife, who's been asked to go back. And she's very keen on the idea of going back on reduced hours because of home education and things like this. So don't assume that your employees may not necessarily want to agree something like this. Certainly on a temporary basis, you could provide for that. It's important that you have something in writing. And from the employee side, of course, they'll want to make sure that it's clear that it's not necessarily a temporary change. Employees can also avail themselves of flexible working rights and that sort of thing. But yes, Angie, I think that's a very good point.
And ultimately, I was just about to move on to, you know, if all of the furloughing in the world isn't going to be enough and you still need to make redundancies. I was just about to go on to redundancies, but a question just came in to ask your views on the payment of an annual bonus scheme, given the bonus was earned on payments before the outbreak.
Yeah.
I think, well, a lot of people I've seen are just saying no bonuses, because providing it's a discretionary, it's not fixed absolute bonus.
I mean, the difficult.
Let's just try and get through this period.
Yeah. I mean, the difficult can be if you've declared the bonuses due, and there's a reasonable expectation of being paid, even if you've got a discretion, there can be a problem there. But on the other hand, I've been advising a company about deferring payment. I mean, it's a different question if you're saying we're not going to pay it at all, I think, subject to what you were about to say, Jonathan. I saw you there with something on the tip of your tongue, possibly.
I was just going to comment on the discretion rebates. I think the discretion is at the time that the discretion is made, and last year might have been a fantastic year, and indeed the beginning of the year looked like it was going to be fantastic in many areas. But if with the crisis, then I think it's going to be very easy to justify it on a discretionary basis. I think in the cases where it's in some way not discretionary as a guaranteed bonus, then it's rather like the situation where you're discussing pay cuts or similar, and you might have a situation where somebody comes up and says this is constructive dismissal because it's a fundamental term of my contract, and I'm not accepting this situation, and then they resign. But then you would probably be able to use a defence of some other substantial reason, because if you had a good business justification for it, and I think tribunals will be probably more sympathetic than ever about the arguments in this particular context.
So going sort of back to what I was saying, Meredith. So if you've done everything, but you still need to make some redundancies, and just before I ask you to sort of talk everyone through what they need to be thinking when they're making redundancies, I've got a poll here just to ask: are you contemplating redundancies within the next 6 months, basically? I'll just publish this poll, and we'll just see, how many of our viewers say yes, but only small numbers, yes, significant numbers, no, we'll continue to use the furlough scheme, or no, we're completely unaffected. So that'll be an interesting poll result to see if anyone's managed to completely be unaffected by everything that's going on. We seem to have had one person at least that's completely unaffected, so that's good. So I'll just leave that poll running for a little bit longer. Hopefully everyone can then put their answers in. I think the extensions to the furlough, I mean, clearly they're being done with a view to sort of staving off redundancies. I do think some employers are just saying, we just want to get on with it. Also, I think the longer the furlough scheme's in place, it enables people to manage collective consultations in a better way, and perhaps so that they don't ever have to collectively consult, but no doubt you can touch on that in a moment. So if I end the poll results there, so 44% are contemplating redundancies, but only with small numbers. 20% are contemplating with significant numbers. 32% say no, they're not contemplating redundancies, they'll continue to use the furlough scheme. So presumably they're the sort of that we think will go sort of bounce back from this fairly quickly, and 4% unaffected. So that's sort of some interesting statistics there. So Meredith, I'm conscious that we said this would only be an hour's webinar, so we've got sort of 6 minutes left. So perhaps you can sort of just run through some info on redundancies and sort of touch on collective.
Yeah.
Well.
Yeah, I can see another couple of questions coming, but we can maybe deal with them quickly at the end. I mean, I'll cover off redundancy. I mean, it's important to remember that the existing law is there. You can't ride roughshod and sort of forget about it, notwithstanding that you'll have a good reason potentially for making redundancies. And I don't think a tribunal, and indeed it's a heresy for a tribunal to effectively dispute or say a business should not have decided to make redundancies. I think that's not a question for an employment tribunal. What they're concerned with is, once you've made that decision, is the process that you're adopting fair? In an individual context, of course, then we would need to consult. We'd need to consider pools. If you're looking at more than one person, we'd need to look at appropriate selection criteria. And we'd need to follow those usual steps, so, inviting people to consultation meetings and giving them the right to respond to any business case that is put forward. But I can see certainly tribunals being very sympathetic to businesses who need to make redundancies in the current context. And yes, in terms of collective, we were anticipating the 15th of May being sort of cliff edge date for beginning collective consultation if looking at making 100 or more, proposing to dismiss as redundant 100 or more employees at one establishment. But of course now, with the reprieve and the furlough scheme potentially extending into autumn, albeit on a phased or reduced pay structure, it's less likely that this will be necessary. But if, and I'm sure the viewers will already know this, but if you are proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, then you must consult for not less than 30 days. And if you are proposing to dismiss as redundant 100 or more employees within a period of 90 days or less, then you need to consult for a period of not less than 45 days. It's a bit of a tongue twister, but that's very important that you begin your consultation within good time. And
one problem that I've seen already is some companies who may have those numbers, they haven't actually got the employee reps, etc., in place. So it's a whole, another sort of lot of administration they need to do to actually get the employee reps, because of course you can't just go to, well, at least in the first place, you need to consult with either the union reps or the employee reps. So you sort of need to factor in some time for that as well, don't they? Yes,
indeed. In the alternative, consult directly with individuals, but there are sanctions, I think, for failing to allow employees to elect, I believe. And another thing to bear in mind is the meaning of redundancy is broader in the context of collective, because it can cover volunteers for redundancy. It can also cover situations where you're terminating and re-engaging with the hope that those people actually won't leave the employment whilst they're dismissed. The hope is that they'll re-enter new terms, perhaps on less favourable terms, but they would also need to be factored in. And if you don't collectively consult when you should, then of course we know that the sanctions can be fairly harsh, with awards of protective awards of up to 90 days actual pay, subject to a special circumstances defence. I'm not sure whether the pandemic is necessarily a special circumstances defence itself, but it may well have led to catastrophic consequences for some businesses with loss of revenue streams where they need to make immediate changes or calling the administrators. Yeah,
certainly historically the bar seems fairly high for it to for you to avoid having to do consultation. Even avoiding administration hasn't been accepted as a good enough reason.
Well, we've got a question actually. Could you complete a process and selection but hold off on issuing final notices until at the end of the furlough period?
I mean, I'd say the answer is yes, and you could even give notice in the furlough period, and there's nothing to stop that happening. The furlough period, of course, is a period where you haven't got any work for an employee, and there's nothing to say that you can't consult and give notice in that period. And there's absolutely nothing to stop those normal redundancy processes taking place. I think collective is in principle the same, but we've had the practical problem that I've had clients where the union is refusing to engage if the people are furloughed. So that's a practical problem, but legally you can go ahead and consult with those people and issue notice. But as if the question here is more along the lines of maybe you're waiting and seeing, and you don't want to give notice because you think, well, actually we might bounce back depending on, you know, how things pan out, then yes, you can do the consultation and give notice. You can either give notice and just say, we will tell you the final date, but it will start now, or hold off giving notice until the end. I've seen that in the past, where a company didn't know what date they were going to close down, for example.
Because I suppose you'll have to, I mean, the requirement to make redundancy at one point in time won't necessarily stand later. So I guess employees may argue, well, things have changed. You know, we happen to know that you're back on track. You've just got some new client business in, and why are you now going ahead with this?
Yeah.
So there might be a question mark there, I guess. But yeah, there's no reason why you can't begin contemplating it and getting a process in place and consulting, as Angie said, because the sooner you do that, the better in some cases. But
I was just going to say, I'm conscious that we're at 11 o'clock now, so I imagine people may have other appointments they need to get on with. I think the only question we've not asked is, with the bank holiday coming up, if someone is furloughed, do we have to pay the bank holiday day in full? And I guess some companies treat bank holidays different. If it's part of holiday entitlement, if it's worded like that, I think the answer is yes, you would need to. But some sort of have holiday plus bank holidays, in which case you may be able to treat it differently. But if you know, if given the time constraints that we've got, thank you, Jonathan and Meredith, for
thank you
those questions and going through everything. Hopefully we've answered everything that you had, but if you have any further questions about any of what we've discussed today, please do get in touch with us. Our contact details, I think they can be found on the invite to the webinar, or you can go to our website, which is www.thomasmansfield.com. All of our direct contact details are on that website. We'd also love to hear from you with any feedback from this webinar. As I said, it's the first one we've done, so if you've got any feedback, good or bad, we won't hold it against you. Please do give it to us, because that would really be appreciated. Our next scheduled webinar is on the 11th of June, where we're due to be discussing restructuring to reduce numbers. Please, again, go to our website and you can register your interest there. Also, if there's any particular subjects you'd like to see, do let us know. We may well sort of slip another webinar into the current schedule. We're thinking about whether to do that at the moment, because you know, guidance is coming out in such a rapid succession. So please do give us any feedback that you've got. And for now, we'll say goodbye and stay safe, everyone. And thank you very much for tuning in to this webinar.
Bye-bye.
Thanks very much. Bye-bye.